In the previous video, we began our discussion about co-ownership, and we identified that there were two different types of co-ownership, namely joint tenancy and tenancy in common. And we began talking about the first aspect of joint tenancy, and in this video we're going to continue with that discussion to talk about things like the right of survivorship and severing a joint tenancy. Since a joint tenant is not regarded as having a distinct share in the co-owned land, he or she is not able to dispose of his or her interests by will on death, nor will it pass on intestacy if no will is made. Instead, on the death of one joint tenant, the remaining joint tenants obtain the interest of the deceased. The last survivor of the group becomes a sole beneficial owner. So, as it says here, in a joint tenancy, the land is held collectively by the joint tenants as a group. So when one of the group dies, the remaining members of that group, even if only one is left, remain as the joint owners of the property. So when you're down to one person, so if everyone else has died within that group, you become the sole owner of the property. In the most common cases where property is held by a couple, so you've got married or unmarried couples in a property, this means that when one of those partners dies, the other, by operation of this doctrine of survivorship, or jus accrescendi, automatically become the sole owner of the property, irrespective of any contrary provision in the deceased's will. Okay, so this is really what the concept of the right of survivorship is all about. But what happens where there is a simultaneous death, where everyone dies at once? And this leads us on to the Law of Property Act 1925, section 184. And it says as follows: in all cases where, after the commencement of this act, two or more persons have died in circumstances rendering it uncertain which of them survived the other or others, such deaths shall, subject to any order of the court, for all purposes affecting the title of property, be presumed to have occurred in order of seniority, and accordingly the younger shall be deemed to have survived the elder. So in other words, what this is really telling us is that if, for whatever reason, everyone died in the house at once, the house exploded, I'm not too sure, then it will be deemed that the oldest person, the older people, will die first in cases of simultaneous death. So the youngest person will be the last person to die within the house. And we have a case of Hickman and PC 1945, where 5 people were killed when a bomb hit an air raid shelter in the basement of a house. Okay, so that included 2 brothers who had left money by their wills to other occupants of the shelter. So we have a situation where 5 people were killed simultaneously when a bomb hit their shelter. And the House of Lords held that, as it was impossible to tell the order in which they died, they would be held to have died in order of age, with the oldest dying first, as we just identified. And similarly, in R.E. Bate, Chillingworth and Bate 1947, a husband and wife died from carbon monoxide poisoning. It was held that the elder, the husband, died before his wife. So these 2 cases are just supporting what is identified in the Law of Property Act 1924, section 184. Okay. There are, however, some exceptions to the right of survivorship, and we're going to look at 2 of them now. So the first one is forfeiture. So the common law rule of forfeiture provides that a person cannot benefit by unlawfully killing another, whether by inheriting or by jus accrescendi. So if you kill someone to inherit the money or the property, and you are later found out, you will not be able to inherit that money or property through forfeiture, by the rule of forfeiture. Okay, so the Forfeiture Act 1982 gives the court the power to modify the rule where the justice of the case so requires. This power is excluded where the person has been convicted of murder. So in REK 1986, Kay was threatening her husband with his shotgun, which discharged and killed him. Kay was convicted of manslaughter. She was also a joint tenant of the family home, thus became sole owner on her husband's death. The court modified the rule to allow the widow to retain the property under the Forfeiture Act 1982. Okay, so just note for 1 second though that the court cannot modify the rule in cases of murder, but this was a case of manslaughter, so the rule could be modified. So what is happening here is that if there has been a murder, so in general circumstances, if you kill someone else that is a joint owner to property and you then become, the sole owner of that property, you wouldn't be able to inherit that property. But there is rule under the Forfeiture Act that allows judges to modify this particular rule in certain circumstances, but only where that isn't murder. If there's been murder in the case, then that rule, the forfeiture rule, cannot be circumvented. But here in REK, there was manslaughter, so not murder, and therefore the court were able to modify the rule to allow the widow to retain the property despite killing her husband. And the second exception is inheritance, under the Inheritance Act 1975. So Dingmar and Dingmar 2006. So Dingmar was a joint tenant with his son of the property in which he lived with his wife and children. When he died, his son became the sole owner of the property by jus accrescendi. His widow brought a claim under the Inheritance Act 1975, claiming that his share of the house, which was the only significant asset owned by the deceased, should form part of his estate. The court allowed the widow half the value of the house at the date of death. On appeal, the Court of Appeal transferred one or half of the property to the widow. So here we can see how the Inheritance Act can sort of circumvent this whole idea of it going directly to the other joint owners of the house. If there's some form of inheritance where it should go towards someone else, then they may circumvent that rule. Joint tenancy is now the only form of legal co-ownership. Prior to the Law of Property Act 1925, co-owners were able to hold the legal estate as either joint tenants or tenants in common. So both of our forms of co-ownership, they could either hold it legally as joint tenants or legally as tenants in common. But after the Law of Property Act 1925, tenancies in common of the legal estate could no longer be created. So if you want to create a legal tenancy in common, that is not possible following the Law of Property Act 1925, section 34, subsection 1. So the Law of Property Act 1925, section 1, subsection 6 held that a legal estate is not capable of subsisting or of being created in an undivided share in land. This means that there cannot be a legal tenancy in common as far as the law is concerned. Legal co-ownership is always joint ownership. And the reason for this change was to make the transfer of land easier, and it ultimately will simplify the sales process. And we will look more at at tenancies in common in the next video, so make sure you check that one out after this one. Statutory trusts imposed on co-ownership. The Law of Property Act 1925 provided in most forms of co-ownership, the joint owners of the legal estate would hold it on trust for themselves. So at first, it would be held on a trust of sale. The Law of Property Act 1925, section 34 to section 36, meant that money made from the sale of property would be given to the beneficiaries, and then since 1997 it was going to be held on a trust of land. So this meant that anyone who bought the legal estate from the joint tenants could take advantage of the overreaching mechanism. And if you haven't seen my videos on statutory overreaching, I would check out that video too, because that will make this sort of section what I'm just talking about a little bit more clear. It also meant that tenancies in common could still be created in equity, with the legal joint tenants holding in trust for themselves as tenants in common of the beneficial interest. So in equity, co-ownership can be either as a joint tenancy or as a tenancy in common. The legal owners may hold the property on trust for themselves as joint tenants, for themselves as tenants in common and equal shares, or as tenants in common in unequal shares. When land is transferred on sale or other conveyance, the transferees can state on which basis the land is held. And I would have a quick look at the TR1 form, so that's the Land Registry Transfer Deed, and you can sort of see that question, that point on the form itself, where you can say how you want to hold the land, on what basis do you wish to hold the land. However, failure to complete this question within the TR1 form will not cause the transfer to fail. The Land Registry will assume you hold it as joint tenants if not filled in. So you have the choice how you want to hold the land. So either as joint tenants, tenants in common and equal shares, or tenants in common and unequal shares. But when you transfer the land, although you have that choice, you also, if you decide not to fill that section in on the TR1, you will be assumed to hold that property as joint tenants. In Stack and Dowden, it was said, if its completion and execution by or on behalf of all joint proprietors were mandatory, the problem we now face would disappear. However, the form might then include an option for those who deliberately preferred not to commit themselves as to the beneficial interest at the outset and to rely on the principles discussed below. So that is a nice little quote from Baroness Hale. Number of joint tenants. The Trustees Act 1925, section 34, subsection 2, limits the number of trustees to a maximum of 4. Where more than 4 trustees are named, the property vests in the first 4 listed. And finally, just to finish this video off, we're going to look at severing a joint tenancy. So a joint tenancy can be severed and the relationship can be converted with the other co-owners into a tenancy in common. If one of the joint tenants wishes to sell or mortgage his or her share of the property, the joint tenancy must be severed. The Law of Property Act 1925 says that a joint tenancy of the legal estate can no longer be severed, but severance of a joint tenancy of the beneficial interest remains possible. By severing a joint tenancy, each of the co-owners become entitled to an equal share under the resulting tenancy in common. And we can see that is true from the cases of Goodman and Gallant in 1986, and also from that was approved by the House of Lords in Stack and Dowden in 2007. Where there are more than 2 joint tenants, it is possible for one joint tenant to sever their interest, leaving the other co-owners as joint tenants of the remaining undivided share of the property. Severance only applies to the interest of the severing joint tenant. Remaining tenants remain as joint tenants. If one of 3 joint tenants sever his or her share, the property will be co-owned by one tenant in common, owning 1/3, and 2 joint tenants who own the remaining 2/3 collectively. In this case, if one of the joint tenant dies, the surviving joint tenant would own 2/3 of the property by survivorship. If the tenant in common dies, his or her share will become part of his or her estate. Okay, so that is the end of joint tenancies as a form of co-ownership. And in the next video, we're going to dive straight into tenancies in common. We've referenced tenancies in common a few times in the last couple of videos now, and you're probably dying to know what it is. So if you have any questions about joint tenancies, just leave a question below and I will answer it as soon as I can. And make sure you subscribe to my channel and give it a thumbs up. Thank you very much for watching.